Guys, Attorney Jesse Arana here. Today we're going to be talking about the three levels of offenses that exist under California law. They are felonies, misdemeanors, and infractions. Felonies are the most serious cases under California law. These offenses include rape, murder, manslaughter, kidnap, and robbery. When charged with a felony, a person is exposed to a potential sentence, that's a potential punishment, of prison and even death. Some felony offenses, however, can be reduced to misdemeanors. Those type of crimes or alleged crimes are known as wobblers because they can wobble down to a misdemeanor. This is done through the Penal Code Section 17B. It's a motion where a defense attorney like myself asks a judge to reduce a felony to a misdemeanor. This can be done before a person is even convicted of any type of offense. The lowest offense that exists in California are infractions. Infractions do not expose a person to any type of jail sentence. Infractions only expose a person to fines and potentially suffering points on their license or having their license suspended. That's driver's license. Infractions include offenses like texting while driving, speeding, improper turn, changing lanes without signaling, etc. If charged with an infraction, a person does not have a right to a jury trial. A person can only challenge the case through what's known as a court trial. The burden of proof is still beyond a reasonable doubt. What's left over is misdemeanors. They are not the most serious cases like felonies, but they're also not the lowest. Misdemeanor offenses expose a person to a potential jail sentence that cannot exceed 364 days. Usually, a person charged with a misdemeanor is sentenced to probation. Misdemeanor offenses include driving under the influence of alcohol, DUI, domestic violence, driving with a suspended driver's license, and petty theft. Some misdemeanors, however, can be reduced to infractions. Those cases are known as wobblettes because they can wobble down from a misdemeanor to an infraction. This can be done either after being convicted or even before being convicted. If charged with a misdemeanor or a felony, a person has certain constitutional rights, including a right to a jury trial. That is where a person can say, I am innocent of any wrongdoing. The prosecutor cannot prove this case beyond a reasonable doubt. 12 people of the community will then decide whether the prosecutor has met their burden of proof, which is beyond a reasonable doubt or not. If you guys have any other questions about the three-level offenses, or if you yourself are charged with any of these type of offenses and require legal assistance, please don't hesitate to reach out. You can reach me at www.jessearanalaw.com, or you can also call my office at 562-392-8209. I do offer free initial consultations. All right, guys, be safe. Bye.